Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Lesson 28. Please like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. Let's get started with question number 1. Sam told Horace, his neighbor, that he was going away for 2 weeks and asked Horace to keep an eye on his house. Horace agreed. Sam gave Horace a key to use to check on the house. Horace decided to have a party in Sam's house. He invited a number of friends. One friend, Louis, went into Sam's bedroom, took some of Sam's rings, and put them in his pocket. Which of the following is true? A. Horace and Louis are guilty of burglary. B. Horace is guilty of burglary and Louis is guilty of larceny. C. Horace is guilty of trespass and Louis is guilty of larceny. Or D. Louis is guilty of larceny and Horace is not guilty of any crime. Take 10 seconds. Choose the best answer. If you chose option D, Louis is guilty of larceny and Horace is not guilty of any crime, you'd be correct. Trespass is the wrongful invasion of another's real property. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. The intent to permanently deprive must be present at the time of the taking. At common law, burglary is the trespassory breaking and entering of a dwelling at night with the specific intent to commit a felony or larceny inside. In this case, Sam gave Horace the keys to his house and asked him to keep an eye on it. Since Sam expressly granted Horace permission to enter his house, Horace cannot be guilty of trespassing. Louis, on the other hand, went into Sam's bedroom and took some of Sam's rings. This is clearly wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. As such, Louis is guilty of larceny. Let's analyze the other options. A. Horace and Louis are guilty of burglary. As we discussed, the burglary requires the breaking in, which neither of the parties in fact did because they actually had the keys to enter the place. So B. Horace is guilty of burglary and Louis is guilty of larceny. We're back to the same analysis where burglary does not apply to either of the parties. As a result, B cannot be correct. Next, C. Horace is guilty of trespass and Louis is guilty of larceny. If you do the analysis again, the larceny option we've not addressed as of yet. We haven't addressed trespass either. Technically, Horace was given permission to enter the premises, so he cannot be guilty of trespass. As a result, option C could not possibly be correct, and option D is the only viable option. Left is your correct answer. Let's look at question number 2. On June 1st, Top Line Wholesale Inc. received a purchase order from Wonder Good Inc., a retailer and new customer, in which the latter ordered 1,000 anti-recoil widgets for delivery no later than August 30th at a delivered total price of $10,000, as quoted in Top Line's current catalog. Both parties are merchants with respect to widgets of all types. On June 2nd, Top Line mailed to Wonder Goods in its own form, across the top of which Top Line's president had handwritten, "We are pleased to accept your order." This form contained the same terms as Wonder Goods' form, except for an additional printed clause in Top Line's form that provided for a maximum liability of $100 for any breach of contract by Top Line. As of June 5th, when Wonder Good received Top Line's acceptance form, which of the following is an accurate statement concerning the legal relationship between Top Line and Wonder Good? A. There is no contract because the liability limitation clause in Top Line's form is a material alteration of Wonder Good's offer. B. There is no contract because Wonder Good did not consent to the liability limitation clause in Top Line's form. C. There is an enforceable contract whose terms include the liability limitation clause in Top Line's form because liquidation of damages is expressly authorized by the Uniform Commercial Code, the UCC. D. There is an enforceable contract whose terms do not include the liability limitation clause in Top Line's form. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. There is an enforceable contract whose terms do not include the liability limitation clause in top line's form. Under the UCC, acceptance may be made in different terms, but whether such terms become part of the contract depends on whether one or both parties to the contract are merchants. If only one party to the contract is a merchant, the additional term does not become part of the contract, but is rather a proposal to be separately accepted or rejected. If both parties are merchants, the additional terms become part of the contract unless 1. The additional term is a material alteration to the contract, or 2. The offeror objects to the change. In this case, both Top Line Wholesale Inc. and Wonder Good Inc. are both merchants with respect to widgets of all types. So the additional term added by Top Line would become part of the contract unless the additional term is a material alteration to the contract or the Wonder Good objected to the change. The additional term in question provided for a maximum liability of $100 for any breach of contract by Top Line on a contract with a total price of $10,000. This is clearly a material alteration to the contract, so the term would not be included or enforceable as part of the contract created when Top Line accepted Wonder Good's offer. Question number 3. A statute of the state of Kiowa provided state monetary grants to private dance, theater, and opera groups located in that state. The statute required recipients of such grants to use the granted monies for the acquisition, construction, and maintenance of appropriate facilities for the public performance of their performing arts. The last section of the statute conditioned the award on each such grant on the recipient's agreement to refrain from all kinds of political lobbying calculated to secure additional tax support for the performing arts. The strongest constitutional basis for an attack upon the validity of the last section of the statute would be based upon A. the Commerce Clause, B. Obligation of Contracts Clause, C. Fifth Amendment, D. First and 14th Amendment. Take 10 seconds. Choose the best answer now. If you chose option D, you'd be correct. First and 14th Amendment. Freedom of speech under the First Amendment is made applicable to states and local governments through the 14th Amendment. Content-based regulations of protected expression are subject to strict scrutiny, meaning the law must be necessary to achieve a compelling governmental interest. The last section of the statute is likely a content-based restriction, since it conditions the award of each grant on the recipient's agreement to refrain from political lobbying to secure additional tax support for the performing arts. Such a content-based restriction would probably not pass strict scrutiny. Accordingly, the strongest constitutional basis for an attack upon the validity of the last section of the statute would be based upon the First and 14th Amendments. Question number 4. Pawn sued Dalton for injuries received when she fell down a stairway in Dalton's apartment building. Pawn, a guest in the building, alleged she caught the heel of her shoe in a tear in the stair carpeting. Pawn calls Witt, a tenant, to testify that Young, another tenant, had said to him a week before Pawn's fall, "When I paid my rent this morning, I told the manager he had better fix that torn carpet." Young's statement, reported by Witt, is A. admissible to prove that the carpet was defective, B. admissible to prove that Dalton had notice of the defect, C. admissible to prove that the carpet was defective and that Dalton had notice of the defect, or D. inadmissible because it is hearsay not within any exception. Take 10 seconds. Choose the best answer now. If you chose option D, inadmissible because it is hearsay not within any exception, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay included within other hearsay, or double hearsay, is not excluded under the hearsay rule if each part of the combined statement confirms with an exception to the hearsay rule provided by the federal rules of evidence. In this case, we're dealing with two statements, Young's statement to the manager and Young's statement to Witt. If Young were to testify as to Young's own out-of-court statement to the manager, then the statement may be admissible to show the manager had notice of a dangerous condition. This statement, however, would not be admissible to prove that, in fact, the carpet was torn. If Witt testifies as to Young's statement, then Witt's testimony would be hearsay because Witt is offering Young's out-of-court statement to prove that Young spoke with the manager. This hearsay would not fall within any exception, so Young's statement, reported by Witt, is inadmissible. Let's move on to question number 5. Ogle owned Greenacre, a tract of land in fee simple. 5 years ago, he executed and delivered to Lily an instrument in the proper form of a warranty deed that conveyed Greenacre to Lily for and during the term of her natural life. No other estate or interest or person taking an interest was mentioned. Lily took possession of Greenacre and has remained in possession since. 15 months ago, Ogle died, leaving a will that has been duly admitted to probate. The will, inter alia, had the following provision. I devise Greenacre to Mina for her natural life and from and after Mina's death to Rex, his heirs and assigns forever. Administration of Ogle's estate has been completed. Mina claims the immediate right to possession of Greenacre. Rex also asserts a right to immediate possession. In an appropriate lawsuit to which Lily, Mina, and Rex are parties, who should be adjudged to have the right to immediate possession? Option A. Lily, because no subsequent act of Ogle would affect her life estate. B. Mina, because Ogle's will was the final and definitive expression of his intent. C. Mina, because Lily's estate terminated with the death of Ogle. Or D. Rex, because Lily's estate terminated with Ogle's death, and all that Ogle had was the right to be transferred, his reversion in fee simple. Take 10 seconds and choose the best answer now. If you chose option A, Lily, because no subsequent act of Ogle would affect her life estate, you'd be correct. A life estate is the lifetime ownership of land. A simple life estate is a life estate that is measured by the life of the grantee. The future interest of a life estate is a reversion to grantor unless assigned to a third-party remainder. A reversion is freely divisible, descendable, and alienable. Here, Ogle conveyed Greenacre to Lily for and during the term of her natural life, which constitutes a simple life estate in Greenacre, with a reversion to Ogle at the end of Lily's life. When Ogle died, his will devised Greenacre to Mina for her natural life, with a remainder to Rex. Ogle's will devised his reversion in Greenacre to Mina, with a remainder to Rex. This device, however, does not affect Lily's current right to possession in Greenacre under her life estate. Therefore, Lily has the right to the immediate possession because no subsequent act of Ogle would affect her life estate. If we further analyze our options and we look at option D, Rex, because Lily's estate terminated with Ogle's death and all that Ogle had was the right to be transferred, his reversion in fee simple. The issue here is relatively simple, that Rex's claim is simply not ripe because he would be subject to Mina's life estate. Given the fact that Mina is bringing a claim here, she's obviously living, so as a result, Rex's claim is simply not ripe. So D, we can remove pretty much immediately. Now, let's look at option B, Mina, because Ogle's will was the final and definitive expression of his intent. The issue here is that it is his final expression of his intent simply because he's now dead, so he has no ability to further express his intent. But that being said, that does not negate the prior life estate which was granted. C is a bit tricky. Mina, because Lily's estate terminated with the death of Ogle. And if you were not aware of the fact that the life estate continued even past the death of Ogle, with only the right to that property returning back to the estate subsequent to the death of the initial grantee, then you might have been thrown off. But otherwise, B, C, and D are clearly incorrect, and the only correct option is A. We're past the halfway mark. Question number 6. Defendant left her car parked on the side of a hill. 2 minutes later, the car rolled down the hill and struck an injured plaintiff. In plaintiff's negligence action against defendant, plaintiff introduced into evidence the facts stated above, which are undisputed. Defendant testified that when she parked her car, she turned the front wheels into the curb and put on her emergency brakes, which were in fact in good working order. She also introduced evidence that in the weeks before this incident, juveniles had been seen tampering with cars in the neighborhood. The jury returned a verdict in favor of the defendant, and plaintiff moved for a judgment notwithstanding the verdict. Plaintiff's motion should be A, granted, because it is more likely than not that defendant's negligent conduct was the legal cause of plaintiff's injury. B, granted, because the evidence does not support the verdict. C, denied, because given defendant's evidence, the jury was not required to draw an inference of negligence from the circumstances of the accident. Or D, denied, if defendant was in no better position than plaintiff to explain the accident. Take 10 seconds and choose the best option now. If you chose option C, denied, because given defendant's evidence, the jury was not required to draw an inference of negligence from the circumstances of the accident, you'd be correct. To establish a prima facie case of negligence, the plaintiff must show a duty, breach of that duty, causation, and damages. In this case, defendant testified that she acted with due care when parking her car. She also testified that in the weeks before the accident in question, juveniles had been seen tampering with cars in the neighborhood. A reasonable jury could believe defendant's testimony, which provides the basis for a jury to reasonably conclude defendant did not negligently cause the accident. Therefore, plaintiff's motion should be denied, because given defendant's evidence, the jury was not required to draw an inference of negligence from the circumstances of the accident. Question number 7. Police received an anonymous tip that Tusitala was growing marijuana in her backyard, which was surrounded by a 15-foot-high solid wooden fence. Officer Boa was unable to view the yard from the street, so he used a police helicopter to fly over Tusitala's house. Boa identified a large patch of marijuana plants growing right next to the house and used this observation to obtain a search warrant. Tusitala is prosecuted for possession of marijuana and moved to suppress use of the marijuana in evidence. The court should A, grant the motion because the only purpose of Boa's flight was to observe the yard. B, grant the motion because Tusitala had a reasonable expectation of privacy in the curtilage around her house and the police did not have a warrant. C, deny the motion because a warrant is not required for a search of a residential yard. Or D, deny the motion because Tusitala had no reasonable expectation of privacy from aerial observation. Take 10 seconds. If you chose option D, you'd be correct. Deny the motion because Tusitala had no reasonable expectation of privacy from aerial observation. A search is a governmental intrusion where a person has a reasonable and justifiable expectation of privacy. An area viewable from a flyover is deemed held out to the public, so there's no reasonable expectation of privacy in such an area. Therefore, a flyover is not a search. In this case, Tusitala's marijuana plants in her backyard were shielded from the ground level view by a 15-foot high fence. So Officer Boa used a police helicopter to obtain a view of the yard. The aerial view of Tusitala's yard was not a search because she had no reasonable expectation of privacy in her backyard from such a flyover. Therefore, the court should deny the motion because Tusitala had no reasonable expectation of privacy from aerial observation. Question number 8. Dominique obtained a bid for $10,000 to tear down her old building and another bid of $90,000 to replace it with a new structure in which she planned to operate a sporting goods store. Having only limited cash available, Dominique asked Hard Cash for a $100,000 loan. After reviewing the plans for the project, Hard Cash, in a signed writing, promised to lend Dominique $100,000 secured by a mortgage on the property and repayable over 10 years in equal monthly installments at 10% annual interest. Dominique promptly accepted the demolition bid and old building was removed. But Hard Cash thereafter refused to make the loan. Despite diligent efforts, Dominique was unable to obtain a loan from any other source. Does Dominique have a cause of action against Hard Cash? A, yes, because by having the building demolished, she accepted Hard Cash's offer to make the loan. B, yes, because her reliance on Hard Cash's promise was substantial, reasonable, and foreseeable. C, no, because there was no bargain for exchange of consideration for Hard Cash's promise to make the loan. Or D, no, because Dominique's inability to obtain a loan from any other source demonstrated that the project lacked the financial soundness that was a constructive condition for Hard Cash's performance. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. Yes, because her reliance on hard cash as promised was substantial, reasonable, and foreseeable. A valid contract requires an offer, acceptance, consideration, and no defenses to formation. Consideration is the bargain for exchange between the parties. A promise is legally enforceable even though there is no consideration if there is promissory estoppel. The elements of promissory estoppel are the presence of words of promise inducing reliance that is reasonable, detrimental, and foreseeable, and enforcement of the agreement is necessary to avoid injustice. In this case, Dominique detrimentally relied on hard cash's promise to loan her $100,000. She had obtained demolition and construction bids totaling $100,000 for the project, and hard cash reviewed these plans prior to promising to loan her the $100,000. At this point, it was foreseeable that Dominique would rely on hard cash's promise to loan her the money. After she had hard cash's signed promise, she reasonably relied on it by accepting the demolition bid and removing the old building. With the building removed, Dominique's reliance was certainly detrimental and clearly foreseeable. After hard cash refused to make the loan, Dominique diligently tried to obtain a loan from any other source, but was unable to do so. Therefore, Dominique has a cause of action against hard cash because her reliance on hard cash's promise was substantial, reasonable, and foreseeable. Let's look at some of the other possible options. Let's look at C and D. C, no, because there was no bargain for exchange of consideration for hard cash's promise to make the loan. That's simply just inaccurate. There was obviously a discussion, there was an agreement on terms, and there was an agreement on 10% interest. So that makes no sense. That can be eliminated and should be eliminated right off the bat. Option D, no, because Dominique's inability to obtain a loan from any other source demonstrated that the project lacked the financial soundness that was a constructive condition for hard cash's performance. Again, irrelevant. This was a bargain for exchange. The two parties discussed the hard cash, reviewed the plans, reviewed the project, consented, signed off, and promised to make this loan. So as a result, neither C nor D, right off the bat, could be possibly correct. We're left with only options A or B. A, yes, because having the building demolished, she accepted hard cash's offer to make the loan. In fact, that is not when the offer was in fact accepted. It was accepted when she began searching for the demolition crew, when she began taking steps in the direction of moving forward and demolishing the building and constructing the new building. So A is actually, in fact, factually incorrect. We're only left with option B. Yes, because her reliance on hard cash's promise was substantial, reasonable, and foreseeable, and that is without question a very fair response. Here, Dominique relied fully on hard cash's promise in taking steps forward, and as a result, not only did she do that, but her doing so was reasonable and absolutely foreseeable, as it is the normal course of action in these matters. Question number 9. Assume that Congress passed and the President signed the following statute. The appellate jurisdiction of the United States Supreme Court shall not extend to any case involving the constitutionality of any state statute limiting the circumstances in which a woman may obtain an abortion, or involving the constitutionality of the statute. The strongest argument against the constitutionality of this statute is A, Congress may not exercise its authority over the appellate jurisdiction of the Supreme Court in a way that seriously interferes with the establishment of a supreme and uniform body of federal constitutional law. B, Congress may only regulate the appellate jurisdiction of the Supreme Court over cases initially arising in federal courts. C, the appellate jurisdiction of the Supreme Court may only be altered by constitutional amendment. Or D, the statute violates the Equal Protection Clause of the 14th Amendment. Take 10 seconds and choose the best answer now. If you chose option A, you'd be correct. Congress may not exercise its authority over the appellate jurisdiction of the Supreme Court in a way that seriously interferes with the establishment of a supreme and uniform body of federal constitutional law. Under Article 3 of the U.S. Constitution, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treatises made or which shall be made under their authority. Congress, however, does have authority over the appellate jurisdiction of the Supreme Court, but Congress cannot exercise this power in a manner that interferes with the establishment of a supreme and uniform body of federal constitutional law. In this case, Congress passed a statute that prohibits the Supreme Court from hearing the constitutionality of any state statute limiting the circumstances in which a woman may obtain an abortion. Under the statute, if a state were to deprive a woman of her constitutional right to privacy, the Supreme Court would be unable to hear that case. As such, the strongest argument against the constitutionality of this statute is that this statute clearly interferes with the establishment of a supreme and uniform body of federal constitutional law. One of the key things here that we must recall with regards to Article 3, and that generally is a trick question, ultimately the Congress has the absolute power to create and destroy the federal courts, all but the Supreme Court itself. As a result, technically, the Congress could in fact shut down the entire federal system except for the Supreme Court. And now on to our last question, number 10. Defendant was prosecuted for bankruptcy fraud. Defendant's wife, now deceased, had testified adversely to defendant during earlier bankruptcy proceedings that involved similar issues. Although the wife had been cross-examined, no serious effort was made to challenge her credibility despite the availability of significant impeachment information. At the fraud trial, the prosecutor offers into evidence the testimony given by defendant's wife at the bankruptcy proceeding. This evidence should be A, admitted under the hearsay exception for former testimony, B, admitted because it is a statement by a person identified with a party, C, excluded because it is hearsay not within any exception, or D, excluded because defendant has the right to prevent use of his spouse's testimony against him in a criminal case. Take 10 seconds. If you chose option A, you'd be correct, admitted under the hearsay exception for former testimony. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is inadmissible unless it falls into one of the three exceptions. There are two possible ways to have former testimony admissible under the federal rules of evidence. If the declarant is unavailable, 1. Testimony offered against someone who had an opportunity to examine the declarant and the motive to conduct that exam was similar to the motive the party has now. Or 2. In a civil action only offered against someone who has a predecessor in interest and who had an opportunity and similar motive to examine the witness in that earlier proceeding. In this case, we have a criminal case, so we can only use the first possibility to have this evidence admitted as former testimony. Defendant's wife, now deceased, had testified adversely to defendant during earlier bankruptcy proceedings that involved similar issues. Since this testimony is now being offered against the defendant who clearly had an opportunity to examine his wife, and the motive to conduct that exam was similar to the motive he would have now, this evidence should be admitted under the hearsay exception for former testimony. Thank you again for joining us on Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so that you can be updated every time we upload new content. It's our aim to upload new content every day at 8 a.m. Eastern Standard Time. If you have any questions or any suggestions, please feel free to add them in the comments below this video. Thank you.